You may see everything,
I'm a
you know,
morning exercise person, so this time doesn't work for me. Not in that
oh,
aspect.
oh, but you can get to do things because the sun is out and it's a good time.
Yeah, in every other aspect, I like it.
Yeah. So I sent everybody the Shantytown decision. I know it's long. Um, and I didn't see anything that jumped out at me. I see where the judge followed, but just gave comments on the various pieces of legislation that applicants had um, referred to the government using their powers underneath the Building Regulations Act, Water and Sewage Act, the Electricity Act, the Bahamas Electricity Corporation regulations, and town planning. But I don't see anything that really jumped out. I mean, nothing. I don't see. I mean, maybe it took a while to find the cases, but I didn't see anything that was really.
You sent that or Miguel sent it?
Miguel sent it.
When?
Oh Lord, what you mean?
I'm
when?
looking for it now. I said
Well, I mean, considering the fact that we just got the cases for tonight's class today.
He
It's a
forgot.
legitimate question.
I think
forgot.
he was out of office. I got
He was out of office.
for him
Yeah, he
last
was.
week. Mm-hmm.
He
Gotcha.
was. Hold on, let me see. Shantytown.
I know he sent several today, so it just maybe that I missed that one.
Yeah, it's probably in there. But you'll see it. I didn't see anything that jumped out at me on the Shantytown to say this is the reason why it took so long.
Hi, good evening all. Miss Archer, I think what it, I think what is a bit confusing, what is a bit confusing for me, thanks a lot. What is a bit confusing for me is I'm trying to figure out like what is governing, what act is actually governing the Shantytown? Because I'm thinking, okay, as an illegal immigrant or whatever, because normally they do, I think some proof of citizenship when they do the title check or when they conveying documents, etc. But if you're illegal and you can't prove citizenship, like how do you get to claim land? That's what I'm trying to understand.
You can't. Apparently inside the Shantytown were Bahamians, they say, and undocumented and documented. So they're undocumented, documented, and Bahamians.
Oh, so they had a combination. So I guess the ones that are documented are the ones that are claiming the land.
Yes. And saying that the government come there and bulldoze their things down just like that.
Oh, okay. Okay.
So
all right. I was trying to figure out.
Go ahead.
No, I was saying it was becoming confusing to me because I was trying to understand how could that happen, you know?
Don't forget now, in the papers last week, they gave the 3-step approach. If you're undocumented, they're going to send you back.
Okay.
Yeah, if you're Bahamian, I think they say they're going to try and find accommodations for you. I can't remember what they're doing with the third set. I think that their people try to accommodate them. Unless they have money to purchase land.
Right. I mean, I don't have anything against them, but I know like sometimes you meet, for example, you meet a Haitian who can barely speak English. They can barely speak English, but yet they have a Bahamian passport.
Yeah. And you know, in other countries, if you're getting a documentation from them, you have to attend classes and be able to speak the language.
Oh, okay. Yeah.
Even to get a student visa, if you say in, let's just say you go into the US and you come from a Spanish or non-English speaking country, you have to take what's called a TOEFL exam. And that requires you to do courses and you have to have a particular grade in that in order to be admitted to college or university.
Yeah, that's true too, Krista, because my son is going to apply for his permanent residency in Canada. And he said he has to take an English test. I said, but you speak English. So he said, no, he even have to do a a pre-test so he can see what the exam will be like.
Yeah, so some of them, unfortunately, are still very archaic in a way because they don't take into consideration that you come from an English-speaking country. They just automatically assume if you're not from our country, you have to take an English test.
Yeah.
Krista, sorry, good night. Krista, so too is our dialect, because I know when my son went to Wake community, the minute he opened his mouth, they put him in an English speaking class. Because he was like, boy, you know, he be using our slangs. And they put him in an English speaking class. I was like, this boy can speak English.
That,
yeah,
I could see that.
Yeah, you have to remember. And then like in Canada, they speak very slowly. So whenever he's speaking to me, I have to tell him speed up because I'm beginning to fall asleep on the phone. But they speak very slowly, you know, and I was, okay, when is the next sentence coming? And he said, Mommy, I can't speak fast because if I speak fast, they say they don't understand what I'm saying.
That's right.
So it's difficult. It's difficult. But one thing they brought out in this shantytown thing that she mentioned was discrimination, because you know that would come out. Discrimination is under Article 26 of the Constitution. It provides a guarantee of freedom from discrimination. And it was the applicant's submission that the alleged policy, which was demolishing the shantytown, and the decisions involving discriminatory treatment because the subject people of Haitian race or place of origin to disabilities or restrictions in comparison to people of the Bahamian race or place of origin who are not subject to such disabilities or restrictions. So in this document, she canvassed all of the legislation that have to do with shantytown, such as cutting off the lights. So she talked about BEC. She talked about demolishing the homes and each one of the government facilities that are responsible for those. And then for further on the discrimination, she say it was proposed to the Honorable Court that there are similarities between the area known as Over the Hill and shantytowns. According to the applicants, Over the Hill has dilapidated housing and poverty. So do the shantytowns. Over the Hill has obscure property title. So do the shantytowns. Over the Hill has a lack of running water and indoor plumbing. So do the shantytowns. The applicants contend in the result that Over the Hill is to be the subject of a regeneration initiative, and yet on the other hand, the shantytowns are to be demolished. So they started to compare the shantytowns like the mud and the pigeon, what is called the pigeon pea. They started to compare them with what we call Over the Hill.
So the Over the Hill, sorry, Ms. Archer.
Go ahead.
The Over the Hill property is owned. It isn't squatted.
Exactly.
Right. And most of those persons, I would say, are in a documented state as opposed to the shantytown. So did they address points such as those?
Let's see. Dion Folks in a David said, my view is that this does not establish any case for differential treatment, as there is no evidence that the attributes of these communities are sufficiently similar as to make them comparators. And then they argued again, the applicants talking about unlawful deprivation of property under Article 27 of the Constitution. That's all these things.
But I'm trying to figure out how you get to the Constitution. Anyway, I probably need to read it, right? Like, so I'm thinking that the Constitution governs the country and the people who are a part of that country or who have properly documented residencies, etc. That's what I'm thinking the Constitution governs. Yeah. I mean, maybe I'm wrong. I don't know. I never read it. It's long. But that's what I'm thinking. So how do you even, I know little pointers though. I mean, how do you even get to that point if you are undocumented? How do you get to that point where you can kind of challenge someone's constitution?
Or claim rights
And
under
you're
the,
not a-
under the Constitution.
Yeah, like how you get there?
That's all right. They get there though. The allegations of impropriety, because they claim impropriety. They said the allegations of impropriety raised by the applicants concern decisions by the government to possess the land, disconnect the utilities, and issue notices to the residents of shanty towns within the Bahamas. Relative to the possession decision, the applicants referred to this as being apparent. After careful review of the plethora of evidence submitted to the court, the applicants failed to substantiate this claim. The court granted the original injunction. The result of this injunction was to halt any potential actions of the government to demolish homes in shanty towns without more until this process was reviewed in depth by the court. Due to the injunction, the government did not have an opportunity to possess the land, even if it had intended to. The main evidence of the applicants relative to acts that could possibly be attributed to possession occurred on the island of Abaco, subsequent to the passing of Hurricane Dorian, which struck our beautiful shores and made landfall on the 1st of September 2019. Hurricane Dorian was an extremely powerful Category 5 Atlantic hurricane, which became one of the most intense cyclones on record to strike the Bahamas and tied for the strongest landfall in the Atlantic Basin. Blah, blah. So the shanty towns were not spared the wrath of Hurricane Dorian. It appeared to have escalated the plans of the government to seek to clean up, assist the indigent, provide aid, and ensure that structures were properly built, rebuilt, and regulated. The court finds nothing sinister in this government policy to restore public health and subsequent to this disastrous hurricane. The court also formed the view that notwithstanding to the amount of information submitted by the applicants who support the allegation that anyhow, the first to fourth respondents and the fifth to sixth, all these are different government ministries and ministers, to disconnect power, water, and utilities for which they are variously responsible from the land. The substance of this allegation was limited, nor unlawful. The statutory process was duly observed and adhered to. The applicant's evidence on this point comprised mainly minutes recorded from the SATF meetings. The applicants also considered that Bahamas Power and Light and Water and Sewage were joined only for the purpose of being bound by the interlocutory injunction which was sought. The court is of the view that this allegation was without merit and akin to a fishing expedition. In the circumstances, the court has ruled that there was not an unlawful policy in place by the government's decision to disconnect the utilities on the lands in question. The strongest case for the applicants, in my view, concerned the issuing of notices to residents of the shanty towns. The applicants raised a total of 9 irregularities pertaining to the notice decision, which they claim was unlawful. The court eventually found the majority of these claims to be unsubstantiated and without merit. The strongest of the accusation levied when relative to grounds 3, 4, and 9. Ground 3 concerned the allegation that the decision was not taken by the authorized individual. The act requires the minister responsible for building regulations, who then was Mr. Desmond Bannister, to serve the notices. However, the applicant claimed these duties were actually performed by the minister, Dion Folks. The court considered the affidavit of Dion Folks to be credible. In this affidavit, Minister Folks stated the notices were issued by the Ministry of Public Works pursuant to their statutory powers. The court is of the view that the actions of then ministers Bannister and Folks may have bordered the line of irregularity. However, I do not accept the line was crossed. I'm satisfied that the decision to issue notices to the inhabitants of the shanty towns pursuant to Section 4.3 of the Building Regulations Act was in compliance with the legislation. These notices were duly signed by the Building Control Officer, Mr. Craig Delancey, who acted in accordance with the Building Regulations Act. And then she said that the policy to demolish the housing, that failed to meet the building code. She said this policy, in her view, was applied with due notice and consideration. And then she said she discharged the injunction on the shantytowns. So the government is free to go ahead and demolish.
This was the recent ruling, correct?
Yes, that's the recent one. You can sit down tomorrow and read it with a nice cup of coffee and a spoon. You know how the English does it?
That made it long.
Yes, it's 60-something pages long. 67.
Okay, Miguel is gonna send it, right? Because I saw 3, I think, cases with some MM something. I only saw those ones.
Yeah, I put MM so you could know it's mastering mortgages.
Okay, so that one is the shanty down. Did the shanty down?
Yeah, it's called Shantytown.
Okay. Okay, all right then.
Anybody got it?
I didn't.
Okay, hold on. He did not send the email with the attachment. And I have to send them one because they're so big, you see? Called. Shantytown. Okay. I tell them to send it. If you don't get it by tomorrow, let me know and I could send it 1-1.
Okay.
Send that for you all. It's me hunting and hunting and hunting until it came up.
We
Thank you very
appreciate your
much.
efforts.
Thank you very much.
Michelle, you ready to talk about Eugene Smith or you want to wait? No? Yes?
I don't see her on anymore. I wonder if she got kicked off.
Hope we got
She's-
kicked. Yeah, she was
Let
on
me-
it. Oh,
Yeah, she was. Let me message her.
see if she's there. So, Krista, you escaped last class, but not this class.
Yes, ma'am.
I say you escaped last time, but not this time.
Understood.
Okay, so let's see if she's around. She could see, let me know if she's doing that. Or what I can do, because I have her here to do the Supreme Court. She was telling me she didn't have the case. I don't know why. But let's have a look at Eugene Smith and Dawn Smith and Clifford Dean. You have that one?
Miss Archer, she said she did get knocked off. Say her internet went down. She's trying to get back on now.
Oh, okay. So she having the same problem I had on Saturday.
Mm-hmm.
Let me see if she's ready for that. Did you get the Credit Reporting Act and the Credit Reporting Regulations?
Yes.
Yes,
Okay.
I saw it.
Okay. We'll go through that in a few minutes. Almost to the day. Oh, he calling me. Why is he calling me? And if I take that, I'll get bumped off, won't I? Hold on, let me see what he's saying. Okay, that was Miguel. He said he looking at a CBC. I tell him if you don't see it, then let me know and I'll send it again. Okay, so Eugene Smith and Dawn Smith. I thought you all would like this case. So Eugene Smith and Dawn Smith and Catherine Smith and Elliot Lockhart, they own a company called DELK Limited. And their client was Mr. Clifford Dean. He was a close friend of theirs, and he was also a client of Elliot Lockhart QC. And he landed in jail. So to cover his legal fees and other debts, Mr. Dean, while he was in prison, he asked them to sell a piece of property he possessed. But the thing is, he didn't have the legal title to the property. So the QC presented the client with an offer for the purchase of the property to the company that he was part owner of in the amount of $250,000. Now, Mr. Dean accepted the offer, and a contract for sale was executed on the 14th of January, 1999. At the time of the purchase, the property was being negotiated. The QC did not disclose to Mr. Dean, his good friend, that he had an interest in the company. Now, remember, when a company is incorporated, it is a separate legal entity. So even though he was an owner, it's a separate entity. So it can transact business. But because he is one of the beneficial owners, one of the shareholders, he should have disclosed that to his client. So over time, the company paid the deposit of $44,700. And they paid over that amount by $18,700. In September 2000, Eugene and Dawn went into possession of the property. Even though that was an agreement for sale, they went in possession of the property. There was no provision in the contract for them to do that. So in 2006, the DELK company assigned its rights under the contract to Eugene and Dawn for $10. The assignment was completed without notice to Mr. Dean, because remember now he's in prison. Mr. Dean retained Wells Legal and Corporate Services, and by way of a letter dated October 2006, he asked for an accounting for the rent that are being paid and asked for the balance of the purchase price. So what the QC did was they sent a check representing the balance, and what Wells Legal and Corporate Services did was they returned it back to Elliot, the QC. And the court said that the appeal was dismissed by Eugene and Dawn. They said the decision was not to grant specific performance was affirmed. Because remember what specific performance is. Specific performance is an equitable remedy, which means that if I have a contract, A has a contract with B, you're going to the court to say B must perform that contract. So the Justice Isaacs in that decision said, contrary to the Chief Justice's opening remarks in this judgment, this case does not illustrate the dangers of an attorney representing both vendor and purchaser in a real estate transaction. Because remember, Mr. Lockhart represented DELK, being a shareholder in DELK, and he also represented Mr. Dean, his close friend, who was in prison. So, and the dangers of an attorney engaging in a transaction with his own client. This case illustrates the failure of an attorney to conform with the principles associated with such transactions. He says, unlike Judge Adley, who was content to find that it was in 2006 that Mr. Lockhart became conscious of his conflict of interest, we hold the view that this realization of such conflict was apparent from as early as September 2000, when Mr. Lockhart wrote to Mr. Dean. It was not until Mr. Dean retained new attorneys that the beneficial owners in DLK decided to bestir themselves into action. They had been content for 7 years to allow the purchase price to be reduced pursuant to clause 13 of the contract. Proffering $205,300 was nothing more than a cynical ploy to suggest the contract was still being observed. And we hold a similar view, that it was a cynical ploy when DELK assigned its rights under the contract to the appellants. That's to the Smiths. The assignment came after Mr. Dean made inquiries of Mr. Lockhart, QC, about an accounting for rents that was supposedly paid under the contract and for the return of Mr. Dean's original documents. We are satisfied that the Chief Justice was correct to focus on the actions of Mr. Lockhart as the respondent's lawyer in the making of the contract, and that the involvement of the appellants in DELK with Mr. Lockhart at the time the contract came into being disables their claim for the equitable remedy of specific performance of the contract and disqualifies them from succeeding on their appeal that specific performance should have been ordered by the Chief Justice. It should be noted that the appellants, as the purported financiers of the purchase through DELK and as principals in DELK, could have insisted that the company move under the terms of the contract to complete the sale. They never did, but were content to allow the purchase price to dwindle as the months passed. And then the judge went with the Latin maxim that he who comes to equity must come with clean hands. He says they were a part of DELK, their lawyer was a part of DELK, and until Justice Adley's decision was DELK's lawyer. It is recognized that DELK's corporate personality is separate from the appellant's personal capacity, but in the circumstances of this case, where equity was being invoked, the Chief Justice's decision not to order specific performance cannot be faulted. So whether the respondent's delay in seeking equitable relief was a bar to his claim, and whether the appellants had acquired rights under the contract by an assignment dated the 1st of June 2006, before the respondent asserted his claim, we are satisfied that there is no merit in any of these complaints in the circumstances of this case. Any comments?
Listening to your recap when you talked about the conflict of interest, the case with the Nixon, Gardy Nixon, those came to mind where that attorney.
Little louder, hold on. Go ahead.
Okay, so can you hear me any better?
Can you go a little louder? Because it's on my own, it's low.
That might be, I don't know, let me see.
Go ahead, I'll put it to my ear.
Okay, sorry about it. No, I was saying that the case with the Nixons came to mind, Gardy Nixon and his uncle and their attorney who had an interest in the company that was purchasing the property. That case came to mind when you were talking about the conflict with Lockhart.
Yeah, but this man is a QC.
So he definitely knew better. But all of them know
Yes.
better. They just choose not to do better.
See, in paragraph 44, in the discussion, he said, we feel sufficiently justified in making this observation because of our reading of the record, and in particular, the decision of Judge Adley, as he then was, dated the 7th of August, 2008, which decision made rather critical findings pertaining to Mr. Lockhart's actions and was not appealed. Judge Adley was called to consider an application by the respondent for Mr. Lockhart and his firm to be debarred from representing the appellants. In granting the application, Judge Adley set out a number of matters which we consider to be of importance to the present appeal, and the relevant paragraphs are set out below. The attorney executed the contract for sale as the president of DELK in 1999, and it was stated by the second plaintiff in his affidavit, which was not denied, that the attorney was a beneficial owner of DELK, along with the plaintiffs and their sister. At all material times, the attorney was also a co-director of DELK with the second plaintiff. The attorney drafted both the contract for sale and the lease. He secured the signature of the client to the contract for sale on or about the 14th of January, 1999. However, up to November 2005, he had not secured the signature of DELK, although deposit monies were purportedly paid under the contract. At all material times, the client was an inmate at Her Majesty's prison. So according to the second plaintiff, when it became apparent that the purchase was not going to be concluded as agreed, the attorney advised that he could no longer act for both sides, and that, quote, because of our dispute, our company, DELK, should assign its interest under the said agreement to myself and Eugene Smith. So by indenture, dated the 1st of June 2006, made between DELK of the one part and the plaintiffs of the other part, the agreement for sale was assigned to the plaintiffs for consideration expressed to be for $10. The assignment was stamped on the 27th of March, 2007. And on the evidence of the second defendant, the assignment was made to the defendants because they were, quote, responsible for paying all funds paid under the agreement for sale and were in possession of a building on the northern third of the property. And the defendants learned of the assignment in 2007. And the judge went on to saying how the attorney had a fiduciary duty to disclose to the client his pecuniary interest in DELK and to obtain his consent to act for both parties and afford him an opportunity to take independent advice. And he did not do so based on the current state of the evidence. And this was a breach of his fiduciary duty, and the conflict of interest caused a breach of the Bahamas Bar Association Code of Professional Conduct. Prima facie, the agreement is liable to be set aside. Because the court concluded that the contract was null and void. Any other comments? So you see how that Latin principle works at equity. He who comes to equity must come with clean hands.
Yes.
And the name of this case, Ms. Archer, this is which one, please?
Eugene Smith and Dawn Smith versus Clifford Dean.
That wasn't sent
Thank
to
you.
us, eh?
Of course it was.
That was the previous one, not the last set he just sent them.
Yeah, in the previous one.
Okay.
When you say the previous one, you mean prior to what we were supposed to get last week?
Yes.
Okay.
No, what you should have gotten last week.
Was included
What you
this
got?
one?
What you got? That should have been in the bundle from last week.
No,
Okay, so even though that was assigned when he sent out the list of names, the actual case was not attached.
Agreed.
right, So we never got the
I
case.
sent one email with the assigned names, and then I sent the cases by itself.
Right, so in the cases, in the email with the cases by itself, it was only 3 cases and this one wasn't one of them.
What?
I
Okay.
I was
have
looking back from you
two.
started, I didn't, I
And
see,
I
okay,
thought
so
I
5,
thought you all were looking at it, you know. Hold on,
No,
let me write it down.
No?
I was doing the same thing, Krista. I was checking through IC Cube
Yes.
Enterprises and Scotiabank Cyril Minnis, but not that one. And then the Central Credit Bureau report. That's all we got.
right, so yeah, we didn't get that.
You want to get that one? Did you
No, ma'am.
get Scotiabank and Ricardo Gibson?
I don't have that one either. I'm gonna see a separate email.
We got the Minnis, which was the Supreme Court and the Court of
No,
Appeals.
that's
so
next
that was-
week. That's next week.
So I went and I crammed for that for this week for, okay.
Okay,
And
well,
then
you
we
could,
got-
okay, well, we could do it. We could do it instead.
But
And
I
then
don't
I'm
know if
gonna find out-
I don't know if the person who has a Supreme Court one is ready, so it would depend on that. Then the only other one we got was Commonwealth Bank and Julian Pedikin.
No,
And a
yeah.
Cube, Scotiabank and Cube Enterprises too.
Yes,
Yeah, but how come you got Scotiabank and Cube, but it's Scotiabank and Cube, Supreme Court, Court of
I'm not
Appeals,
moving.
and then you should have
yes, we have
David
those two.
Stratton and Scotia and Ricardo Gibson.
I don't see Scotia
No,
and
I don't
Ricardo
have
Gibson.
Okay, so I need to send that one too. I don't know why it's missing. And that one. You have David?
No. I don't know if anybody
Um,
else saw it, but I didn't see it.
2 for Cyril Minnis, Cube, and that's it.
Okay.
Was that Cyril Minnis and who? Can you repeat
Yes.
that, please? That's Cyril
Sorry,
Minnis and who?
Scotiabank and Cyril Minnis. So it's one where he appealed it. So I think it's one where Scotiabank is suing him and then he appealed it. So we have 2 for him.
Thank you.
And then you have Commonwealth Bank and Pelican.
Oh, Lord.
Let me double check. I don't remember.
Yes, I saw Commonwealth Bank and Pedikin.
Oh, yes. That was in the same email. So it was 3 in the email, 2 for Cyril, 1 for Pedikin in one email together.
Can I ask a question of the anybody else in the class? So I actually don't see the attachment for Scotiabank v Cube.
That one, that came today at 5:48 when I think you and Dame said that you didn't, or I think Krista, you might have been the one who said you didn't see the
I
attachment.
didn't. So I got the 3 attachments. I just didn't get the listing of who was presenting.
Oh,
It's a
okay.
separate
Today
email.
at 5.
So the email he sent today at 5:48, that has Cube in it and it has Scotiabank.
Ah, got it.
Yeah.
Got it.
Okay.
Got
You
it. Got
see
it.
it?
Okay. So Ms. Archer, I actually prepared for the wrong one. I prepared for the Court of Appeal for minutes
Well, you can do that one.
for today.
Yeah, you can.
Okay, even
Okay.
without doing the Supreme Court first?
We could always read the Supreme Court because the Court of Appeal is the final decision.
Okay.
Go ahead.
All right, 1 second.
You said something about Scotiabank and VQ. How do you spell that VQ, please? Because I don't see
No.
any
Cube.
cases.
Versus Cube, CUBE.
Versus Cube.
Check the email that
CUBE.
came at
Okay, I don't have those.
CUBE. Yeah, check the email that came from Pratt at
Okay.
5:48 today. Mhm.
All right, thank you. Ms. Archer, you can't repeat the last thing you said. You just said something that I wanted to ask you about.
What's
I don't
that?
remember what it is, but anyway,
It'll come back.
the last comment you just made. Okay.
I can't remember. Okay, Christy, you gonna do Cube?
No, if it's okay, I could do Cyril Minnis.
Okay, go ahead.
All right. Since we're not looking at the Supreme Court case first, I will do my best to give a little bit of background, so we know where we're coming from. Okay, so this case was originally between Cyril Minnis as the plaintiff, and I have the Supreme Court one here. First defendant, Commonwealth Bank. Second defendant, Armando Talbot. Third defendant, Tiffany Dennison. All right, so in August 2006, after holding a discussion with Armando Talbot, the appellant, who was Cyril Minnis, because this is now the appeal, agreed to pay off in full a mortgage debt owed by Talbot's company, TEL, to the mortgagee, Commonwealth Bank, which had fallen into arrears. TEL's mortgage with the bank was secured against a commercial property owned by the company, which the appellant, Minnis, ultimately wished to acquire. At the time of his discussion, the appellant was not told that TEL had already executed an agreement to sell the property to another purchaser, KFL. He was also unaware that TEL had already executed a conveyance of the property to KFL. So essentially, by the time he came about having this discussion of acquiring the mortgage, I should say, the sale of the property to KFL, the other purchaser, was already well underway. I believe that there was maybe a 6-month, 8-month period in between, if I'm remembering the timeline correctly. Additionally, he was also not told that the original title deeds related to the property had already been delivered by Commonwealth Bank to Mr. Talbot's lawyers, Dennison and Co., to be held in escrow, subject to the mortgage debt owed by TEL to the bank being paid in full from the proceeds of the existing sale to KFL. So August 2006, still unaware of the sale, Minnis's, the appellant's attorney, Hal Tynes, wrote a letter to the bank representing that Mr. Minnis had agreed to liquidate TEL's mortgage debt in exchange for TEL mortgaging the property to him. Now, this was to the sum of a manager's check for $103,258.29, which was the payout amount due to settle the mortgage debt as of that date. The letter requested the bank to forward the relevant title deeds to Mr. Tynes in order to facilitate preparation of a deed of, pardon? Oh, I thought someone said something, sorry. In order to facilitate preparation of a deed of transfer of mortgage from the bank to the appellant. On the same day that the letter was issued, a meeting took place at Commonwealth Bank between the appellant, Mr. Tynes, his attorney, Mr. Talbot, the mortgagor, yes, and the bank's representative, Mr. Davis. During the meeting, TEL's mortgage was settled in full, with the bank only undertaking to provide a satisfaction of mortgage. Fast forward a little bit. So in the weeks that followed, having received no documents from the bank, the appellant made further inquiries only to discover for the first time, so after his money was already gone, that Mr. Talbot was in the process of completing a sale to KFL. Upon making this discovery, the appellant pressed to obtain the title documents from the bank as per the request in Mr. Tynes' letter. During this time, Ms. Dennison was of Dennison and Co. had the documents in escrow and was refusing to return them to the bank. She said she was unable to release the title documents, having been mandated by a Supreme Court judge's order to complete the sale between TEL and KFL. Let's see. So at the end of the Supreme Court case, the appellant, Mr. Minnis's claim against Mr. Talbot was dismissed by consent. Sorry, that wasn't at the end, that was at the beginning. So remember, I stated that there were several defendants in the case when it was first brought to the Supreme Court. However, most of those defendants were dropped off, only leaving Commonwealth Bank for the trial. So following the trial judge found that there was no breach of contract between the appellant and the bank, and the bank had only agreed to execute a satisfaction of mortgage in exchange for full settlement of the debt owed. The appellant's claim against the bank was dismissed in its entirety with costs awarded to the bank. The appellant then appealed. Okay, now, this brings us now to,
Sorry, I'm back, Ms. Archer. Sorry, Krista.
no, that's fine. So, by way of notice of appeal motion filed on November 1st, 2017, Mr. Minnis sought an order that the written judgment of 13th of October, 2017, which I just summarized, be set aside in its entirety. He relied on 11 grounds of appeal, which I'm going to try my best to summarize for you. The notice of appeal purported to name as respondent the bank, and again, Ms. Tiffany Dennison, notwithstanding that she had been removed initially as a party to the proceedings. So going through, Mr. Minnis claimed that the trial judge erred in law in allowing the first defendant, Commonwealth, to rely on hearsay evidence, stating that this meant that he was unable to, or his attorney was unable to cross-examine the witnesses. He also said that the trial judge erred in discharging the second defendant, who was Almondo Talbot, the primary, I guess, or beneficial owner of the company that owned the property. So erred in discharging the second defendant, both as a defendant and as a third party. He also said the judge wrongfully decided the case on the failure of proving that a contract was established between the appellant, Mr. Minnis, and the respondent, Commonwealth Bank, when the appellant paid off the loan in the name of Talbot Enterprises Limited. Mr. Minnis further claimed that the evidence that he paid the sum of $103,258.69 that was predicated on his intent to purchase the property from TEL, and that the mortgage would be satisfied and the title deed released to his lawyer. Accordingly, the pure law contract was improperly applied, according to him, to the facts of this case and the failure of the first respondent, Commonwealth Bank, to do what both parties agreed on before the appellant's party departed the bank, made further negotiation of terms unnecessary. So the evidence recited mentions paragraph 21 and 25 when you read it, of the decision of the trial judge clearly indicated the true intent of the appellant was that he intended to purchase the property thought to be owned by Talbot Enterprise TEL, as opposed to lending money to TEL. So, Ms. Archer, I'm gonna go over number 5, but this one I wasn't 100% clear on. So I may seek your interjection here. So number 5 states that the court erred and wrongfully decided the issue, an equitable principle of subrogation, which just by definition means the substitute of one party by another in respect of a debt or claim. It's usually accompanied by the transfer of any associated rights and duties. And then it says, and accordingly, it came to a decision which was against the weight of the evidence, which was and remains that on the payment of the sum of money to the first respondent, Commonwealth Bank, which the first respondent accepting knowingly and with the benefit of an access to competent legal advice, the appellant became a subrogee unfettered by the niceties of the principles of privity of contract. Okay, I'm gonna stop right there and ask you to please go into that a little bit, or at least clarify that a little bit.
Okay, so here he is saying that Commonwealth Bank, right, accepted his money and knowingly, and then they took advice, and the appellant then became a substitute for one of the parties. And the thing he's saying is that they were unfettered. When he said the principles of privity of contract, he's meaning that in order to enforce a contract, you have to be a party to that contract.
Right. Ah.
Or offer and acceptance. So I don't know why he put all offer and acceptance.
Mhm.
Because privity of contract is talking about the document itself and whether or not you're a party to it.
Okay,
But he could be referring to the offer and acceptance, meaning that an offer was made and they accepted.
right. That's what he's claiming. And as we go further into this appeal, that actually comes up as, if not one of the main issues, if not the main issue, whether or not there was an acceptance of the offer.
Right. And that
Okay.
means that there was an agreement.
Right.
It's not a contract, it's an agreement.
Understood.
Mhm.
Thank you. All right, so moving forward, the claim was, so I'm still going through the claims of the appellant. Claim that the judge failed to recognize that the object of subrogation was and is to effect a fair and just balance between the rights and interests of the parties concerned. The judge failed to find that the equitable interests acquired by the appellant as a subrogee continued to attach to the property. That the judge erred and misdirected herself when having found as facts that by the date of the commencement of the action, being October 1st, 2008, the property in question, again, unbeknownst to the appellant, had already been sold to another purchaser. And also her findings that by August 2006, when the mortgage was paid off, the respondent knew and had actual knowledge that the property had been sold to another purchaser. So what he's trying to say here is, when he handed his funds over to the bank was already aware that this property was being sold. So it's saying, yet despite those facts, the judge wrongly found that the first respondent was not liable to the appellant. Accordingly, the failure to find on those specific facts that the first respondent was obligated to refuse to accept the appellant's money, or at the very least owed a fiduciary duty to return the money because of the date of the payment of the money, the first respondent knew it no longer held the title documents. Such a decision amounted to a miscarriage of justice. Appellant is also claiming that there was a fiduciary duty owed to the appellant for the money it received while knowing it could neither deliver the satisfaction of mortgage nor the title documents, notwithstanding its promise to the appellant to do so. So initially in this appeal, remember Ms. Dennison was also named. So she made a preliminary objection. And we find that if you're following on page 12, so we will return to discuss the merits of the various grounds of appeal shortly. However, we pause to briefly mention a preliminary objection filed by Ms. Dennison in advance of the hearing, which clearly had implications both for her continued presence at the hearing as a named respondent, as well as for the propriety of grounds 2 and 10 out of the 11 that were named. So the notice of preliminary objection alleged that grounds 2 and 10 of the purported appeal were incompetent vis-a-vis Ms. Dennison, in as much as the trial judge's order of October 6, 2015, which originally dismissed her as a defendant, had discharged her from the action. So Mr. Minnis, during that initial trial, had never obtained leave to appeal her discharge as required by rules of court. After this was discussed at length, the counsel for Mr. Minnis during this appeal, Jethro Miller, conceded the point, and Ms. Dennison was discharged as a respondent in this appeal, and which further dismissed grounds 2 and 10 out of the 11, with costs awarded to her. All right, now we go into the Court of Appeals summary and findings. So counsel for Mr. Minnis submitted that the learned trial judge erred in law when, in according to her decision, she referred to the witness statement and letters of Mr. Hal Tynes, who was, and correct me if I'm wrong, the attorney, but he'd passed away. He further submitted that the judge erred in allowing the witness statement of Mr. Rupert Roberts, the then local manager of the bank, into evidence, as he was not called to testify at the trial. Mr. Miller submitted that the witness statements were hearsay, and further that the unavailability from the trial of these two witnesses, whose witness statements had been left in the trial bundle, operated to the prejudice of Mr. Minnis. So essentially it operated against him. However, the Court of Appeal found that Mr. Miller's submission on this ground were unconvincing for the following reasons. No objection had been taken by either counsel to Mr. Tynes' statement being relied on, and accordingly, the trial had proceeded on the basis that Mr. Tynes' witness statement was to be used. What was more, the all-important letter of August 2006, which had been written by Mr. Tynes, again deceased, to the bank, lay at the heart of Mr. Minnis's pleaded case. So he himself was relying on this quote-unquote hearsay evidence that he was trying to say should not have been used because the witnesses couldn't be called to testify. As to Mr. Roberts' witness statement, it was clear from the transcripts that counsel for the bank, Mr. Robert Adams, initially applied for leave to rely on Mr. Roberts' statement, but eventually withdrew the application as the statement had already been made a part of the agreed bundle of documents to be used at the trial. There was an initial objection by Carlson Sherlin, who represented Mr. Minnis at the trial, to the use of Mr. Roberts' statement. But it was then observed that Mr. Sherlin, again himself, sought to make use of it at the trial on the very next day. So moving ahead, again, if you're following, we're going to move ahead to page 14. So looking at grounds 3 and 4, breach of contract. These two grounds were considered together in as much as they raised challenges to the judge's application of established contract principles. So at paragraph 43 of her decision, the learned trial judge stated, the law is clear. To constitute a valid agreement, there must be simple acceptance of the terms proposed. Further, where an offer has been made, but the terms are not accepted, there is a counter offer. The counter offer then puts an end to the original offer. So this is coming back to, in the beginning, trying to make the point of whether or not there was an acceptance that would then possibly lead to stating that, okay, there was a contract or there was some type of duty of loyalty or obligation between the appellant and the respondent. So the court further went on to say, as we understand the submission, Mr. Miller was in essence suggesting that the trial judge ought to have sidestepped longstanding principles of contract law and crafted or fashioned a remedy which would have assisted Mr. Minnis out of his dilemma. So what they're essentially saying is that Mr. Miller, the legal counsel for Mr. Minnis, was trying to make it the judge's responsibility to, I don't know if I want to say twist, but kind of finesse to make it where it benefited Mr. Minnis. Going on to grounds 4.1 and 4.2, they complained that the trial judge paid inadequate attention to and or ignored Mr. Minnis's evidence of his intention and or his agreement to purchase the property. So the court went on to say, as will readily be appreciated, nothing in Mr. Tynes' letter, if you go back and read it in the Supreme Court case, to the bank mentioned anything about Mr. Minnis having agreed to take over or purchase the property in question. That letter only basically said that they were going to pay off the mortgage or pay off the mortgage to the bank and then become the mortgagee for TEL or Mr. Talbot. All right, so still on grounds 4, in the final analysis, we found no fault in the trial judge's decision that there was no breach of contract between the bank and Mr. Minnis. It is clear from Mr. Tynes' letter that an offer was made by Mr. Minnis to pay off the debt owed in exchange for Talbot's Enterprise Limited mortgaging the captioned property from him. There was absolutely no evidence that Mr. Minnis's offer had been accepted by the bank. As the judge correctly found, there was only evidence of a counter offer to provide a satisfaction of mortgage. So they never agreed to give him or hand over the title deeds, which again were being held in escrow. So grounds 5 and 6 on the subrogation point of, let's see what I pulled out here. So the court said, as we see it in this case, Mr. Minnis's pleadings were woefully deficient in placing the subrogation issue properly before the court. In his statement of claim, Mr. Minnis claimed to be a subrogee for Mr. Talbot, meaning a substitute. However, this could never be the case as it was TEL which owned the mortgage debt. Sadly, in order to, notwithstanding that Mr. Minnis's pleadings in relation to the subrogation point was not properly pleaded. Sadly, in order to rely on the contractual subrogation principle, Mr. Minnis had to plead that by paying off TEL's mortgage debt, he ought to be regarded in equity as standing in the bank's shoes as a secured creditor. Unfortunately, that argument was not made during the trial. All right, coming down to the last few grounds here, grounds 8 and 9. So number 8, Mr. Miller complained that notwithstanding that the learned trial judge found that the bank knew that TEL had sold the property to KFL, she still failed to find that the bank was obligated to refuse to accept Mr. Minnis's payment on the mortgage, or at the very least, to find that the bank owed a fiduciary duty to Mr. Minnis to return his money. And in the circumstances, her decision was a miscarriage of justice. This is a restatement of the appellant's stance on the matter. The court, however, responded, we were unable to follow how a fiduciary duty could be said to have arisen between Mr. Minnis and the bank, for the simple reason that the circumstances which were alleged to have created the suggested relationship were never pleaded or even set out in the statement of claim. As we see it, even if the existence of a fiduciary duty had been properly pleaded, it would not have succeeded since there was nothing in the record or in the evidence which established that the bank undertook to act for or on behalf of Mr. Minnis in any way. The bank was not a fiduciary to Mr. Minnis. It owed him no obligation of loyalty. And in the absence of pleadings, the judge could not be
called. So she's buying cases from all different banks. You may not know about it. You may know about it, or you may not.
Miss J, your mic open.
Mm. Oh.
So it owed him no obligation, and in the absence of pleadings, the judge could not be faulted for not addressing the issue. That's all right. Ground number 9. As we understood this ground, this is the court again, Mr. Minnis's complaint was that the court failed to find the bank liable for willfully or negligently misleading him. Once again, negligence was not pleaded in the statement of claim and was not an issue which the judge had to be determined. So in conclusion, this is described as a very, very sad case. And while the court had sympathy for poor Mr. Minnis and all the money that he lost, they were unable to find merit in any of his grounds for appeal. In contractual terms, Mr. Tynes's letter mentioned in Mr. Minnis's pleadings was no more than an offer which was not accepted by the bank, which in exchange for Mr. Minnis's manager's check merely undertook to provide a satisfaction of mortgage and no more. In short, there was quite simply no contract between Mr. Minnis and the bank for delivery of him of the relevant title deeds. We found no fault in the learned judge's decision to dismiss Mr. Minnis's action against the bank, And for all the foregoing reasons, we dismiss the appeal and award costs to the bank to be taxed if not agreed. That was sad.
I hope that
Everybody got that?
I hope there's a follow-up
Yeah.
case where he sued Talbot or yeah.
Or the company or something.
Right,
Yeah,
because he knew exactly what was going on. He got his mortgage paid off, and he sold his property and got full proceeds from that sale and left that man hanging. But I know that man.
What the pay cost.
Exactly, but I know Mr. Minnis, and I trying to figure out if that gone down like that. Mr. Talbot still walking the line?
Mr. Talbot still walking the line. I know the case.
You know the case?
I
I was working for Commonwealth Bank at the time.
Okay.
Yeah, Mr. Minnis just got a big mouth, Stace. You know, all the law abiding line. He settled down.
What? No bite to that bark?
No bite. You just gotta throw the
Lord.
bark back at him, and he settled down.
See, in the Supreme Court, right? It say Mr. Talbot discussed with Mr. Minnis the sale of his property. She's looking at lots 10, 11, and 12 in Block K in the industrial area. And it was mortgaged to Commonwealth Bank, and it was in arrears. So Mr. Talbot went to him for assistance. And he said he made an agreement with Mr. Talbot to pay off his outstanding balance on his mortgage. Then he said he went to a meeting to Commonwealth Bank with Mr. Davis, Mr. Talbot, the attorney, Mr. Tynes.
And the daughter.
And then he said Mr. Davis, as the agent or servant of Commonwealth Bank, gave him an undertaking that the bank would comply with the agreement. And he gave them a check for $103,000 and the change to extinguish the debt. But he said after he paid the money, he never received the satisfaction because he didn't know that at the same time he had already made an arrangement, Mr. Talbot, to sell it to Kelly's.
Miss Archer, you know what I found strange? Why aren't there different type of contracts? Like, just because I know the court said that there wasn't anything in writing from Commonwealth Bank, but based on the meeting that was attended by more than one person, so you had a witness to what was said. There's nothing in law like an unwritten or verbal contract. And the fact that he gave this money in good faith based on what was discussed, there's nothing that the court could have relied on in that instance.
But by him paying that debt doesn't make him privy to the contract between
Talbot and
the bank. Right.
Yeah, between
Mr. Talbot was
between the mortgagor and the mortgagee.
Right. No, I understand that, but was it Mr. Talbot wasn't in that meeting and didn't give consent, or wasn't a part of the whole agreement?
Like that. But he has a mortgage. He has a mortgage deed.
Right. He has a mortgage deed, but my thing is the conversation, from my understanding, went to say, okay, my mortgage with you is in arrears, right? So the bank, instead of the banks looking for vacant possession and going through the hassle of finding a buyer and or whatever, he is saying, okay, someone is going to satisfy that debt for me, and in return, I'm telling you that you can turn over these papers. Was he in that meeting when the discussion took place with Davis? He was a part of that to say, this is what I want to happen?
He was
He
there.
had to have been, because no discussion
Right, that's what I'm saying.
No discussion
Exactly.
held without his presence.
Right, so that's my point. So there's a mortgage between Commonwealth Bank and Talbot, but Talbot is telling the bank, I'm in arrears, as opposed to you having to go through legal action, selling the property, getting vacant possession. This person is going to pay off my loan, and I'm giving you permission that when you do the satisfaction, you give it to them. All of this was discussed with, all of them together in the room. So I'm trying to figure out why that can't stand. That's like a verbal agreement that was made. Commonwealth Bank obviously agreed to it because they accepted the money, and not just that, they sent an email to Denison later on asking her to return the documents.
Yeah, but Stace, the thing it is in it all, until that property still belongs to Talbot. So although Minnis would have paid off the property, it doesn't give him ownership of the property. It just
No.
Right.
cancels
No.
Talbot's debt. Now Talbot
No.
in return
Mhm.
taken sold the property to Kelly's.
Right, that's what I'm saying. So somewhere along the line, even if it's not, okay, you say Commonwealth Bank had no obligation. It was
Had-
just a
Should be
discussion,
indebted
right?
to him for something, $150,000
Commonwealth
to pay that man
Bank, just like every other bank, once you don't pay their money, what you
That's
owe,
it.
that's all they concerned about. Now, what happened around the corner has nothing to do with them. See, Menace and his era did not get an obligations from Talbot, a bill of sale or whatever from Talbot.
Mm-hmm.
And so
But the
I try to
property
figure
still
out now.
Talbot's.
So Mr. Menace is a businessman. You trying to tell me that he went into Commonwealth Bank and gave them a check for $103,000 plus and had nothing in writing with Talbot to say what their agreement was?
Did he bring it before the court?
You
So
didn't
that's
bring it
the
before
difference.
the
It have to
court.
be another case.
Wow.
Mr. Archer need to
That's
look
what
for another
I'm
case.
telling you.
Yeah,
Yeah, you gotta find
Yes,
I've
that.
heard of
Talbot,
people.
have to
I've
be
heard of
another
people
case.
trying to do business on a handshake.
No, sir. No,
Not,
sir.
not this
people do
man,
though.
not this man we talking about.
Exactly.
Oh, okay.
We need
yeah,
to
that's right.
check.
You know him personally.
We need
Yes.
to check either the Supreme Court for a case with him against Talbot or check the obituaries. One of the two. Something wrong.
Well, Talbot is very much alive, so the obituary won't stand. And you know, Menace is very much alive. But we want to know, maybe Talbot gave him complete bus and stuff. Yeah, I know he gave Menace the money back. I know that.
Right?
Probably from the sale of Kelly, he paid Menace because it wouldn't have gone down like.
Probably.
That's what
Mhm.
I'm wondering. But Menace
Yeah.
probably didn't want the money back. He probably wanted the property because the property probably had more value to it.
Yeah, but the property was already sold.
Yeah, because for all there was what 3 lots of land, and the
Yeah, 3
settlement
lots.
was only 103,000.
Yeah,
The
so you
balance
know
on the mortgage, right.
Talbot won the money.
And you see who he sold that to? Kelly's.
Okay,
Mhm.
so Talbot was able to, off the record, I
So
suppose.
James, where this
give
property
Menace-
is?
That's the civic industrial area, James. That's like around Queens Highway or something.
Queens Highway in the back there, yeah.
Yeah.
That's
Okay,
where
so
that's
use
a
it for
commercial
storage.
area.
Yeah, commercial. Lots of storage spaces. But
I could look and see if there's another case after these.
trust me. Talbot sold that property to Kelly's and he probably got about 300,000. He give Menace the money back, and that's all Menace could argue for. And Talbot walk away with 200. That's how that gonna end.
Yeah. They probably didn't go to court. They probably just settled it between themselves.
Yeah. Well, Talbot is still alive and Menace is too.
Okay. And they're probably still good friends after he paid him.
I know about all that. Mr. Menace is something else. Oh, Father.
But you see the things that happen, right? That's why I
Mhm.
like to bring the cases so y'all can see how these things happen in real life.
But Miss Archer, you know what is so amazing? And like I tell people all the time, okay, I might not be a mechanic or a contractor, but I know banking, right? And you give
Mhm.
people your advice, but people always think they can win somewhere. And I always tell them it is in their best interest to do so legally, whatever you're going after. You know, yeah, it can cost you a couple dollars, but it will save you much more in the end.
Mm-hmm.
But you know,
I
the first
agree.
thing they say is you don't want them to have something. You hate
Yeah,
them or something
yeah.
like that.
Especially when we tell them they ain't qualified.
That even worse, right?
Yeah, they hate you. You don't want me to have nothing. And then it's get
Yeah.
taken away anyways from them. They don't listen.
Well, it happens. I tried to find you all some cases.
But Ms.
On
Minnie, I
homeowners
mean, Ms. Archer,
protection
it would be interested if you could follow up on that one to see what Minutes would have done.
Okay, if he went to court, I'll see if there's
Uh-huh.
anything.
Uh-huh.
Yeah, if he went to court and sued him.
Right.
Yeah. Okay. So understanding the mortgage process, we know that each bank has its own requirements, competition for mortgage loans. I saw in the papers today, Royal Bank had a full 2 pages of all of their mortgage staff across the whole Bahamas. Anybody saw that in the papers?
Unfortunately, we don't get papers here in Crumple.
Oh, no. But they had the pictures of every,
James,
every
stop that. Go
branch.
right by Bellevue and they got paper. Stop it, James.
Well, they had it for every branch was there. And all the people's photos and their telephone numbers. So Royal Bank means business.
They were even on the news, I mean, on the radio with their thing, with their campaign
About mortgages.
about mortgages.
Yes.
Inviting you who have mortgages with other institutions to come on over.
Mm-hmm. Because remember Scotia did that when they started with their 3.99%. Remember that?
Yeah.
So they're doing the same thing. So the competition is stiff because as people are now being re-employed, they see an opportunity now for persons to I guess apply for mortgages, and you have a lot of young people who are getting jobs and they can also apply for mortgages. And so then a lot of people who have regular homes, young people like in their late 30s, they're trying to get condominiums and townhouses. And so there's a lot of movement in the banks now as people try to get these mortgages. So everybody know the mortgage rate is tied to the prime rate.
Yes.
And I just gave you all a little bit of history of the prime rate and how it moves. So normally when they quote a rate, they'll quote a rate prime plus. And that plus is the percentage point that the bank uses for the margin. So what I wanted to discuss today, because I know you all know the mortgage process, loan origination, loan underwriting, and loan administration. So the application stage is the stage where you normally start to go through all of the personal and financial information of the borrower. So yes, you fill out now the application form, you put in the address, whether they have any children, whether they have their own occupied home or they're still renting or they live at home. You get their employment history and you get their salary, you get their pay slip, and then you look at their credit and debit history to see if they pay, I guess, their debts on time. And you get appraisal of the subject property that's to be mortgaged and any other information that you need. So the next step will be the assessment. But before we go through the assessment, I wanted us to have a look at the legislation, the law that goes with credit ratings. I know you all have it there handy. So under the act itself, under section 19, I know it's big. Yep, section 19. You could be charged for services by the credit bureau under section 8 in the act. It speaks to the credit bureau protecting the data subject's confidentiality. And if they contravene that, they're liable to a fine of $10,000. And then there are limits on disclosure in section 10. They can disclose credit information, and it has to consist solely of information sourced from publicly available publication. So a credit bureau has if they have reasonable grounds to believe that the disclosure of the information is authorized by the data subject concerned and is made either to a debt collector or a landlord or agent of a landlord, or they made it to a prospective employer or an agent or an insurer or a person in connection with a business or credit, they can use that information. And they can also charge a fee to actually get that information from them. Now, the credit provider, if they deny information, whether it's in whole or in part under Section 11 of the Act, the data subject has a result of information contained in the credit report. They have within 15 days after making the decision, they can do an adverse action notice informing the data subject of the name and address and phone number of the credit bureau that provided the information. And the data subject has a right to dispute that information with the credit bureau. Now, when it comes to the regulations go a little bit deeper, and it speaks to under Section 8, refusal, where am I? Part 2. Hold on. Let me get there. Not part 8, part 2. Limits on disclosure, 11, 13, okay, 14 in the regulation. So a data subject, in order to dispute the completeness or accuracy of information contained in a credit file, submit to the credit bureau a notice of dispute. And the notice of dispute has to be in writing. It has to give the details saying what is incomplete or inaccurate or erroneous or obsolete. And I also have to give information regarding the action required or requested or to be taken by the credit bureau. And the credit bureau has 5 working days after they receive this notice. And they have to attach a note to the data subject credit report warning that there is a dispute under investigation. And then they have to give the credit information provider a copy of the notice. And then they request confirmation from the credit information provider as to the accuracy of the information. And the credit bureau shall retain or cause to be retained a copy of the notice of the dispute on the file of the data subject until the dispute is resolved. And then the credit bureau that receives the notice of dispute has to investigate the claims of the data subject, and they have 15 working days to do that. And if they think they're going to need more time, they have to advise the data subject that they require more time. So the credit bureau, if they're of the opinion that the information on the file is complete, is accurate, it's been verified, they could advise the data subject in writing of their right to file a statement of dispute. And any information in the file of the data subject is found to be incomplete, inaccurate, erroneous, obsolete, be verified. Within 7 days, they have to update the information, complete it, correct it, and delete anything that's erroneous, obsolete, or non-verifiable. Then they have to advise the data subject if they have any other steps that need to be taken
I going again?
No, I think Miss Archer went out.
Oh, okay. Stace, I see you the host now.
Me?
It just said that. It said Stacy Knowles is now the host.
I have no reason. I have no idea why. Is she off completely? Let's see. Oh, she
it
dropped completely.
Oh. Because something just flashed to say you're the host.
Oh, I don't know why it would do that. That's sad.
Hi, I have a question. Good night.
Good
Good
night.
night.
We'll be giving loans to people who worked at a bank, like
Yes,
mortgages.
ma'am. Yes, ma'am.
Okay.
I'm back.
Okay.
Okay, great.
So
I'm getting.
Forbes, you could see us.
I think
Hey,
she's in. If she,
go ahead.
No, Ms. Archer, we was just trying to solicit Forbes for a mortgage.
Oh God.
All right.
You really want that hanging over your head for 20 years?
Yeah,
You
I
do?
see a duplex. I see a duplex that I'm interested in.
are you in Nassau?
Pardon me?
You're in Nassau?
Yeah, in Nassau.
Okay, I'm gonna send you and I'm gonna PM you the name and number for our manager in the mortgage center.
Okay, all right. Thank you.
So y'all are just avoiding RBC and their big ad, colorful.
Miss Archer, don't do it. We start as low as 3.99% too.
So they did not rate.
Hmm?
No, because their rate is not 3.99. And there's
Yeah.
other things behind it too. So Forbes, let Stacy give you the contact. Don't mind Ms. Archer.
I'm only teasing.
I know.
Now, when I about this the credit bureau, have you all had any issues with the credit bureau?
Yeah, some in that the credit bureau don't have every bit of information.
Yeah, because it takes time to put it together.
And you find that customers come in and they could tell us more about their loans, their loan facility than the credit bureau can. Because in some instances, the credit bureau is reporting that the mortgage or that the loan is paid off and very well, the customer still has a loan. So I don't know where they're getting their data from, but I suppose in time it will all get corrected.
Yeah. So I guess a lot of the provisions that they put in the legislation in terms of the data subject being able to file a dispute will probably take time. Unless, of course, the bank uses the information, denies the credit, then it depends on the data subject, then they can actually approach the credit bureau and file a dispute.
Well, I don't think that the bank will go to that initiative and that, we're still governed by the central bank and I don't think they won't go up against central bank. But the thing it is I don't propose, at least let's just stay hopeful that this credit bureau be around. Because we know Bahamians is make loans everywhere. And I believe the credit bureau don't believe some of the credit information that they're receiving. To think that one person will probably take home $12 in their salary.
Or you mean they don't believe it, but it actually happens.
It does happen.
But they have other sources of income that they're not going to disclose.
But the boyfriend?
Whatever.
That's what I'm saying. So according to lending, we only go on jobs. I mean, and on the means of your employment, not that you have a boyfriend who can give you all the money. And so we still have to stay within the 45% of your salary, not your gifts, right?
Right.
And so I believe that the credit bureau, if they see Ms. Archer with owing 5 different banks and taking home $10, they'd be like, no, maybe one of these were paid out. And that's my thing about the credit bureau.
Hmm.
Why they probably not believing the data they're receiving.
Yeah, but we have 2 big pieces of legislation, and it'll be like the legislation now for collection of taxes. It's on the books, no one follows it, and then all of a sudden they tell you it's fully enforced.
Okay,
And then you gonna have real problems because right
real
now,
problems. Like
right,
this real property tax thing too. These
yes,
people- Mhm.
yes, everybody is complaining. But the minister said this is what the law says. We are going to collect our taxes.
Well, they gotta find some money for the public purse. And they're so sorry. It's the poor people who always gotta pay the cost.
Yes, so all those with their little small businesses, they need to have their tax compliance certificate. All people with Airbnb, all of those are going to be taxed.
Ms. Archer, God forbid that they really crack down on this NIB. And I feel like they're going to go after the NIB collections. Because NIB,
Already going to be,
yeah, their funds are near the depletion. And so they're gonna go hard after those people who are outstanding with their NIB contributions.
yeah, they're going hard. They're going hard after them. I know they're actually trying to put some of them in court.
I'm telling you, it's ridiculous though.
Yeah, so they have to go behind them to collect those funds.
That's what I don't get to, Ms. Archer, not taking off of the subject. If you told my employer, if you gave my employer the responsibility to deduct my national insurance contribution, my portion, and the employer isn't transferring it over to NIB, I have evidence where it was deducted from my salary. But when I go in to make a claim, I can't claim because my employer didn't send the money over.
But
That's
they have
just not fair.
Yeah, they have many of those, and that's why NIB says that you have to once in a while, at least once a year, check to see if your contributions are being posted. You have to check. The onus is also on you. You can't wait and work to a place for 10 years and then suddenly get sick and you go there and they say, oh, we had something for 2 years, but we don't see anything else. And then come to find out the person you worked for during that period, the company no longer exists and the people are nowhere to be found.
Mhm.
Then you
Wow.
and then you have a lot of people who don't work.
That's why what I believe, a lot of people are now doing early retirement because they fear by the time they wait for 65, ain't gonna be no money in NIB for them to get.
But that's true too. But you get that at a reduced rate.
They ain't mind because they say they ain't know if they can live, but let them get their money.
Well, we'll see. They probably gonna have to increase the retirement age. Other countries have done it around the world, but they weren't.
I think the debate is to take it to 72.
Oh my God, we'd be crawling in Pampas.
Yeah, they're thinking to extend it to the age of 72.
Oh,
Which is
I
now the retirement age in the Turks and Caicos.
but they have a different lifestyle from us. They don't have- I know France, the people were protesting. I think they took theirs to what, 62 or 64. But a lot of countries around the world have moved their retirement age after COVID.
Mm.
A lot of countries have done that.
So less or more?
More,
Okay.
yeah. But theirs were already low. Theirs were lower than ours. We were at 65.
Oh, okay.
Yeah. So it's a balancing act. But the thing about it is, even if we increase ours, that's whereby the government doesn't have to pay out a lot of money. We still have a lot of people who need help from the government.
Yeah.
So that means that a lot of the people who are here and working, they have to find a way to make them inclusive so that they pay NIB.
Yeah.
That's the thing. A lot of these self-employed persons, they're gonna have to pay NIB. Because by the time you see them get 60, 65, they're going to NIB for their little small amount. But they haven't contributed.
This is so sad.
Yep. So they're gonna have to bring them in line.
So, Ms. Archer, do you think they're kind of discouraging investment properties? Because I mean, if you're kind of taxing or leaning heavily towards taxing investment property as opposed to single family homes, do you think that's something that they're discouraging?
No, I don't think they're discouraging it. Just that the government needs money. And what they're doing is just trying to enforce what's on the books. Now, you could take up the suggestion put out by the governor, which is try to revert to tax. That's something that you have to put in your mind because the IMF is already pushing for that. And that's not the first time that they've said it. So if we pay a lot of taxes, we get nothing back. But if we implement income tax, we'd be able to get some returns from paying all of our taxes. But right now,
the thing I'm looking at, right? Like every time the taxes increase, I think we need to focus on the management of our money.
I agree with you.
Like they need to be held accountable. I mean, you know, a job is not worth 50,000. The job only worth like 20,000. You still paying out $50,000 to get kickback. I mean, let's manage the money.
Yes, there's a lot of corruption, and it's a part of our what should I say? It's a part of our
DNA. It's a part of our DNA because I don't care which government go in place, they want kickbacks.
Yeah, so it's a culture that's ingrained in us, and we have to change it because we're not going anywhere. We're not moving, and I want as Bahamians, I want you all to open your eyes and look at other Caribbean countries. Other Caribbean countries are doing what it takes to survive. They're building from the inside. We are not. In another 10 to 15 years, they will have surpassed us. They are actually in their country producing, cleaning up, growing, building. And what are we doing?
Important.
Yeah, dressing up, walking around, being fancy, but we're not trying to sustain ourselves. We're not doing enough to even to export.
Ms. Archer, it's because the money lies where money lies. And the thing it is that it stays in one circle, you know, and then if you look at the other Caribbean countries, they invest in the people.
Yes, they are investing in the people, but that comes back to the same point. The same is that we are paying all of these taxes now, but there's no investment in us.
None.
You build an airport for tourists. How are you investing in us?
I'm paying so much though, Ms. Archer. You giving them so much money so they could come and I say rape you.
Yes, because
they're not managing the money. They need to manage the money.
They need to invest in the people. COVID was 3.5 to 4 years. Why aren't we out there training these young people? I see the time change now that the country is open. Look and see how many people could be having babies soon. A bunch. A bunch. Who could feed them? Who could feed them?
Ms. Archer, I watched this commentary on Saudi Arabia. You know, they're in the desert. And so they realized that then their staple food was just dates. And so what the government did was that they did irrigation from the ocean so they could give the plants water. And what was so amazing, and it comes back to us, if we're really interested in this backyard farming, and in fact looking at farming as an offset to what it is that we do in terms of Saudi Arabia now has become self-sufficient with their foods. And they gave carte blanche to the farmers. They bought them their equipment, they give them interest-free loans, you know, they invest in their people. And so now today Saudi Arabia is self-sufficient.
But hold on, did not our people go there too?
Exactly, but they went there to see what they could get for them.
Right, didn't bring anything back for us.
Nothing, nothing.
I mean, you could have had schools here. I mean, there's enough foreigners here. You could have had people learning, these young children in government school learning all kind of languages.
Exactly.
They could have been learning how to build tables, chairs, all them kind of stuff.
And
Nothing.
even co-op, you know what I mean? And they collaborate with those other countries who done do it, you know? Even if you get to send couple over to learn and bring back home, all of our children, we're getting also brain depleted because all our young people are going off to colleges and not returning home.
No, because they say there's nothing here for
Nothing
them.
to do. Exactly.
That's the problem. We're not
You
focusing
What
on
happened to
education or
Bamsey, Miss
empowerment.
Archer?
What happened to it?
Bamsey? The Bamsey. Bamsey. That's the name of it.
Bamsey
Whatever
all the-
happened to the Bamsey project?
It's there. It advertises. I think once a week you hear them saying how they're actually on East Bay Street. They put their table on the side of the road for people to come to buy the products. I think they have different markets on Saturday, but that's only one
I
island.
mean, they had a base in South Andrews, right?
And
Is that still there? I mean, are they?
Yeah.
Oh, okay.
It's still there.
It's still there. Yeah, Bamsey was on the other day talking about it, that they're going to look now into egg farming. But the thing it is that Bamsey is only one little place.
Right.
That's not enough.
Exactly.
It's good, but it's not enough.
But we have the opportunity to bring people from all around the world. I see those people, just like you were saying, in those countries. They show you where they had water. They move the water and bring land, and they're farming and building condos and sky-rise building, and people driving cars up in the air and coming back. What happened to us?
You see what I'm saying?
We're too focused on tourism, and it's not that there's anything wrong with being focused on that and continuing to build that industry, but you right now, you're packing up all your eggs in one basket. The only thing you want to build is a whole bunch of structures, amenities, attractions to bring persons in, but that's not sustainable.
No, what about the people?
Agreed. So that what are you creating? You're creating almost like a servant mindset to tell the people that, listen, you need to be working for the rest of your life at these resorts and stuff like that. It's never that you're going to accomplish anything or say that you have something for yourself. You're always going to work in the service industry because that's the only industry we're focusing on.
But Krista, even so, let's say even if tourism is our industry that they're focusing on, like Ms. Archer said, what about the people? Because by this time,
But that's what I'm saying, Ms. Forbes.
factories.
I'm agreeing with
how to make mattresses, how to do whatever it takes for the hotel to run. Have a big farm that only
all the foods for the hotels could have been done right here. Fresh lettuce, fresh cabbage, fresh tomatoes. Why can't we have that?
Yep. Yeah. So Ms. Forbes, I think you understood. I'm not saying that that's how it should be. I'm saying that unfortunately that's the current climate of our leadership. And it's a sad state that we're in and we're continuing to perpetuate.
I'm telling you, if we sit here and we wait, all the other Caribbean countries will surpass us. We don't even make shoes. Jamaica does make shoes. Slippers. People in Africa make them by hand and sell them around the world. What is wrong with us?
That's not our fault.
I don't know
And the thing
if
about
some of
it is
this
you would
this
think
behavior may be intentional. I just can't
To keep you
get over
down.
it. If this
It
is
is.
intentional,
it
like
has
you
to
go to
be.
It
these
is.
things, you know these things, etc. It's just like some places of employment and what's not. Like they know how to better their service. They know how to do it, but they just don't do it. It's there. Everything is there, but they just don't do it. They prefer to go back historic and continue in the same trend when they know technology has changed and there are better ways of doing certain things.
Yeah.
So it seems to be, I don't know, embedded somewhat in our culture. I don't know what it is.
No, I think it's just a vague mindset. It's like you come to power and then you bring all of these people 70 and 80 years old in the ministry. Come on.
Persons who are older than the independent country that we know. Not that
Exactly.
there's anything wrong with that, but that can't be your main.
They can't be at the forefront.
No.
Because those kids in primary school and middle school should all have computers. This is a
Yes.
different age. I watch a man at Dunkin' Donuts. He was pushing the numbers and then he got stuck. And I'm looking, this is a grown man. He was lost and confused. And I asked the manager, I said, oh my God, how do you do this? She said, miss, you really don't know, it's hard.
Our workforce isn't even competitive on a Caribbean stage, much less a global stage.
They're not quick. It's just not there. I don't even know how they could function in the banks. How? Some people still adults and counting on their fingers. How is that possible?
You see it when you go in the grocery stores.
Or that even worse.
Some-
Do not miss and say your bill is $12.15 and you give them $22.25. They lost.
That's it. They short circuit.
Yeah, they can't.
Completely. There's always that lost look at the beginning, like, huh? I don't understand.
No.
And then you have to tell them, I did this because I want a straight 10 or a straight 20 or something like that. You kind of have to coach them.
Gotta be exact.
Yep.
Can't do it. It's a problem. It's a problem. And you're gonna find that in the financial institutions, you're gonna have that same problem and they're gonna mask it. And when you all are no longer there, my God, I'm sorry for the banks. Because they're gonna be giving out money, don't have a clue. They'll be approving the loans, have a clue. And so what's gonna happen? Again, a lot of things are gonna be outsourced to Jamaica, Trinidad, wherever else. Because you just can't do it. They can't comprehend. Just can't. What you saying, Fountain? You're very quiet.
All right, I'm listening in. I'm taking note of all the concerns, Kev, of my good group here, and I hope one day I could, be of assistance to help address them, because these are real things. These are real pressing matters, and the only way for us to really change them over time is to really set some serious policies and guidelines in place in relation to funding is one aspect, education is another aspect. It's just so many things that have to be changed and have to be done in order for a lot of these things to come into place. I mean, there's even a lot of things that have to be done to get the money into the right places, like NIB and whatnot. But it's really number one thing is a matter of changing a lot of mindsets. I'm breaking up a lot of just poor thoughts and poor established principles that we really use to kind of run and govern. Most of actually it's really more so pervasive here in Nassau, than anywhere else in the country. And the sad part about it is NASA is the largest economic hub, so it's more pronounced here as well. But there are ways and systems we could set up to get ourselves on the right track. But it just really requires having the willingness really to stop, analyze things, and then make the adjustments. And then from there is the ability to just make sure that we're doing what we are saying that we would like to do. Because it's good for us to sit there in this forum and just talk about all these problems. But at the end of the day, we talking the people who could do something, they talking with all kind of foolishness and nonsense, and ain't even really giving any of this any real consideration because they don't care. So it's just a matter of really and truly finding the right ways to make the changes and get the changes done so that we could have something to look forward to in the future.
I see a lot of it too, where like the young people like yourselves who were elected, you can't hear anything from them. It's like
yeah, they
everything.
silent.
Yeah, silent. Like
And you can see them right
Yeah.
before next election.
that can't help me. That cannot help me. I don't understand. I don't understand.
Ms. Archer, that's us as a people. That's us as a people. We just can't stand together. To me, that is, if one person raise a voice, may have 2 or 3 gather, and then it just dies down because you don't get the support of the people.
Yeah, but we have to do something because how the pandemic is over, every country is trying to stand on its own legs and try to make up for that time. It's not just about collecting money. It's about getting your people ready. Other countries are pushing.
And the only thing we're praising is the fact that our tourist arrivals are more than they were, post-pandemic, this same period of that year. Okay,
But isn't that elementary?
I would think
You
so. I would
expect-
really think so.
That is nothing to make noise about.
No,
Anywhere,
that's nothing special that we're doing.
nothing. Nothing. People just want a place to go. But I do think also that the financial institutions, even though I think in the papers last week, they say Bahamas Development Bank has a huge amount of monies outstanding. People would have borrowed money for various projects and never paid. That's another problem we have. You cannot borrow money and not pay. Just because you borrowed it from the government.
Ms. Archer, there we go again. The collection efforts is just not there. They don't make these people, I guess, because it's the government, you don't really got to pay it back.
No, you have
That
to-
almost goes back
I'm
to
saying
the
that's
sense
how
of
they-
entitlement as well.
Yeah.
Government owe me-
that's
government owe
entitled.
me
That's
something.
government money. You didn't pay that, you
Yeah.
need to pay that back. That's government money. That's
Mhm.
just like student loan program, went off to
And,
school, got
okay,
educated.
the hurricane loans,
They have to pay that money back.
they don't pay them.
But they put the right people in power, they will get it done.
Agreed.
The right people who are not searching to get rich. People who want to make it better for the people of the Bahamas,
Real
not for
civil servants. You come
We
in
need-
servant leadership.
we need a-
That's what you're
We need a
supposed to
Mia
have.
Motley. We
well,
need a
hold
Mia
on now,
Motley.
hold now,
That don't play.
now, because your man of business thinks he is her,
Oh,
the prime minister.
Ain't ready for her.
no, no, sir, no way.
In which
She
fantasy world?
the class all by herself.
All by herself.
Yeah,
She
but she
don't play.
is, and he stands right next to her.
Really better let her rub off on him.
No,
because
ma'am.
he ain't there yet.
That can't happen.
Notwithstanding with all what is being said, and all my love for Mia Motley, I have great admiration for what she does. Respectfully, the Bahamas don't need a Mia Motley. We need people who are just willing to start thinking from the positions that they in. Like the guys up there in Parliament, they just are not using their brains. They are sitting there, banging on the tables, not really trying to do anything
I
except for
But
push
that's why
I
agendas
agree with
along.
you, Mr. Fontaine. I definitely do, but there's also, and I'm going to say it, a criminal element to it as well. That yes, you have those who are sitting there inactive, not doing anything, but you have others who are sitting there capitalizing on their position. And
Every
that should never be allowed. And you hear about it in the public arena, but nothing ever really, no real consequences are usually levied against them.
Yep, that is very true. I'm not even sure you really even deal with situations like that, except for putting in actual policies, like anti-bribery things, anti-corruption laws. We have some acts, but we just have to enforce them.
But
No,
here's the
that's
thing,
like going to
who
Princess.
enforces them?
I
Go
was
ahead,
just, that's like going to Her Majesty's prison, or they rename it now, whatever the prison name, going there and asking the criminals to make some laws governing their behavior. That's the problem.
And
we
then
have
to
right now.
enforce their own laws on themselves.
Exactly. Yes, and that's not gonna happen.
No, yeah, that's not it. We were said earlier talking about like the Constitution. When the Constitution have a lot of things set up in it, we just have to expand a few things. Like now we have the Department of Public Prosecutions and the Attorney General. We need to really just reshape and change those roles, make them much more independent. You give them some more independence, they can act and function on their own. Then they could they'll have more of the teeth. They'll have more of the actual bite behind their bark if they so choose to use it, and they'll have a reason to do it if their roles are more independent and subject to different things, which would keep them in office. So there's, like I said, we have a lot of what we need already. It's just restructuring, resetting ourselves, getting on the right course, and just really trying to figure out where we want to get things in the long run. Nassau and the Providence and the Bahamas, we have one of the oldest parliaments on the side of the world, but we just really been farting around for the longest and not really doing or developing anything from it, and we have governments that call themselves progressive, but they only progressive in spending money. We have governments
spending money and making money for themselves as well.
Right.
Yeah.
Making
So-
the people who they want to make rich get rich.
Exactly.
And everybody does that. I ain't saying it's one color or the other color.
No, it's all, but that's why I made the comment that you're asking the same people that's a part of the problem to police themselves. None of them are everybody pushed the can down the road when it came to reforms with campaign funds and so forth, the public disclosure, anything that would put them on blast or make them accountable. We don't see it being enforced. Like you say, the rules are in the book. That's why I say you're asking, that's like asking the prisoners to enforce the law or whatever, because they are the criminals. The ones who we need to be protected from are the ones who are in parliament. A lot of them talk a good game, but once they get in, everything that they say they're going to do make reforms and changes and stuff, it goes out the window.
It absolutely does. They make false and empty promises for the most part. And then when it comes time to really say, okay, this is what I'm actually implementing, all of a sudden now we're backpedaling for this reason or another reason.
Exactly.
Or this excuse or another excuse, I should say. And then, yes, I definitely agree. We have certain laws and everything in place. But then again, we also have enough people who are in positions of power, whether obvious ones or not so obvious ones, who know how to finesse the system, who know how to find the loopholes. So when you hear things and you're asking yourself, well, how? Because that sounds almost criminal, but no one's paying fines or going to jail. It's because they found the loophole in how to do it. So to you, it sounds criminal, but they did it in such a way that you can't prove it.
Mhm.
What about instances where you can prove it? Look at the case this evening with the QC. Still living high up the horse. Looking pretty and smiling. A big QC.
How many QCs we have, Miss Archer?
Plenty.
How many the other Caribbean countries have?
I don't know how many they have. But several.
As far as I know, I don't think as many. I could be wrong, or I could be misquoting some information I heard recently, but it seems ours are a little bloated in numbers. But I could be wrong.
But even looking at our criminal laws, I mean, they could have amended them a long time ago.
They needed to be amended a long time ago.
But everybody's just dancing around. Oh, it's the courts. Oh, it's the people themselves. Oh, it's the parents. Like, get serious. They're not serious. And then in a recent decision, the judge made a comment about people fronting. I mean, those businesses on Bay Street, please tell me how come no one knew that the people who are working there didn't have work permits?
No way.
How come no one could realize that the people who were running the stores were fronting? Come on, and Stevie
You mean the
Wonder.
Pakistanians? Oh, it's a lot in a jewelry store. Come on now.
Yeah.
Come on now. Those jewelry stores get a lot of them fronting now.
Not only the stores, because remember that was the scene for the hit and the two hits, but
Yeah, but in recent times, like, there's been a proliferation of them. I think there was a recent case that came the other day. They talked
So-
about who's
yeah.
fronting for who.
right. But you saw the ones with the people selling those expensive cream on Bay Street. They have some stores selling creams. They were fronting. And
I didn't see that and I didn't hear about it, but now that you say that, you know, I passed there either Sunday past coming from church or last week Sunday, and I noticed some people walking around. I mean, coming from one of the stores by the door, because there was a lot of tourists out, but they was outside on front of the store with like cream in their hand, and I said to myself, "Is that cream they selling?" Right?
kind
of
cream?
This is the store that used to be, well, I know the location used to be Scans at one time, right? In
Yeah.
front. As soon as you pass the market, there's this little small little road there, and then a little shop right there on the corner. There was
What type of cream you're referring to, though?
Looks like
Listen to
like
me.
they having testing the tourists this cream thing on their skin and thing.
Yes.
Oh.
So this case was
I
heard
just noticed that Sunday.
Supreme Court between Tal Nemza and V. Yusufon, the plaintiffs, and ZRK Limited, the defendants. So those two gentlemen, Nemza and Yusufon, they brought an action against ZRK Limited for breach of a management agreement and or negligence in the performance of the management agreement. So in or around August 2016, the plaintiffs, those same two gentlemen, Nemza and Yusufon, they entered into a management agreement with ZRK. The management agreement was supposed to allow the plaintiffs, the two gentlemen, to manage and or operate a cosmetic beauty supply business from the property that they leased from ZRK for 5 years on Bay Street in downtown Nassau. So they're supposed to be in the business of selling beauty supplies. And you'll see here where the owners asked the two gentlemen, say it appears that the management agreement between the parties was used to facilitate the circumvention of a widely known public policy in this country that retail business in cosmetics is reserved for Bahamians. He said, I'm satisfied that this is not merely a public policy issue by a statutory illegality, as the true owners of the business are not reflected on the business license. And he says, the venture appears to have been operated in contravention of various laws relating to immigration, national insurance, and VAT. An agreement such as the management agreement entered into by the two gentlemen and ZRK is to be avoided. They were fronting. So they evicted the two gentlemen and their business. And that's when they came before the court, and the court said there was nothing wrong with ZRK evicting them. But ZRK themselves created an invalid management agreement.
You'd be surprised to know who's the principals behind ZRK.
Oh, it's in here. I could give you the name. It's in here. I think it's a Greek. The Greeks. What's their name again?
Scandalaris.
There you go. Them. They were the ones.
You want a
Very
name?
fitting name.
Scandalaris. Skandalaris. ZRK submits that the two gentlemen opened the business without a business license. How is that possible on Bay Street? How?
Who you know? Who and whoever else is behind.
So
Whose
listen.
pocket
So,
getting lined?
Okay,
Exactly.
that's what I wanted to say. Who pocket?
so one of the plaintiffs, one of the two gentlemen, emailed Scandalaris about getting the business license for the business. So the business license in the shop had the name of Emmanuel Scandalaris and not the name of the two people, the two gentlemen. You don't think they know better?
Of course.
Mhm.
Say come to Bahamas, you can do anything and get away with it.
Yeah, but this is another example.
Money talks.
So Nemsa was an American who lived in Florida. And it says that it was ZRK that owned the cosmetic business carried out on Bay Street. He says he managed the business along with Yusufan under the management agreement with ZRK. And according to Nemsa, it was agreed that he and Yusufan would be responsible for the renovation and furnishings of the storefront and payment of rent. So this arrangement all came about when Yusufan met Antonius, John, and Emmanuel Scandalaris while they were here on holiday. 1 year later, they executed this management agreement.
They hatched that plan.
Yes. And he said Emmanuel Scandalaris assumed responsibility for obtaining all the regulatory approval necessary for him and Yusufan to operate the cosmetic business. They even had a franchise and sub-franchise agreement between them. And he said the cosmetic business had very little cash sales. That they stayed open for a very long time. Never went to the Bahamas Investment Authority. None of that. It's just corruption all over. Corruption, corruption, corruption. I don't know what to say, what to do. It's tough.
I guess you just need to look right.
It's rough. All right, so the rest of the chapter is things that we've done already. Just talking about the process and executing the mortgage. So for next week, we're gonna look at practical examination of legal documents. Have you received copies of the mortgage deed? Let me know now so I could remind Mr. Pratt to send it.
I didn't see one.
I didn't either.
Okay, all
I
right.
have not.
You have not? Okay,
Nope.
all right, okay. I'll make sure he sends it. And I'll see if I can find some cases that refer to mortgage deed, so you can see how the court interprets those. All right. So I know I have to send or make sure you get Eugene Smith and Dawn Smith, and FPL versus. And you say you didn't get Shantytown either?
No.
Okay.
I saw a mention of it in the body of an email, but I didn't see any attachment or anything.
No, okay, I sent that. It's big, maybe it did. But I know I sent that. Okay, so those three, I'll make sure he sent tomorrow, and then I'll look for some cases related to the mortgage deed. So you can see how the court applies those. All right. Oh, and y'all want me to look up Mr. What's the man name again?
Cyril
Minutes.
Minutes.
Cyril Minnis versus Talbot.
Charlton.
Admondo Talbot or something like that.
Yeah, look up his name. Almondo.
Or against the company.
TEL.
Talbot
TEL.
Enterprises Limited.
Or TEL.
Yes.
Okay. Let's look up. Okay, I'll see if I can find anything on it.
Ms. Archer, I know I had asked Pratt. I got my exam results, but I had asked him if he could send the questions for the exam to match the answers too. He said he was going to check with you.
You mean multiple choice?
Yes. Because I mean, I know what answers I didn't get right, but I don't know what the question was.
Oh, okay. And who doing the supplement on Wednesday? You don't have to say.
We can also go through them in class if you don't want to stop the physical questionnaire.
No, I can send it.
Okay.
I can send it to you. I can let him send it to you. I made a note here. So anybody who is taking the supplemental, the exam is already at the office. So I have it scheduled for Wednesday. There's some other students taking a different exam, and so they'll be at the office, but it's there. It's not difficult. It's very simple. Hold on. There is no, before I say it, and then I have to take it back. Hold on, because I wrote it on Saturday. Here handy. Yeah, there is no case law.
Does this enhance the grade or replace the grade?
Enhance.
Can anybody take
Who's anybody?
it? Asking for a friend.
No.
Asking for a friend.
Or do you,
Anybody
or
who
is
need enhancement.
is there a minimum score to qualify you for taking it?
Grade is 70. If you got below 70, you need to take this.
Man.
What you mean, man?
She want to pad her grades so she could look good going into the finals.
What you mean? Get points.
Ms. Archer, for those who are taking the supplemented, you're going to average between the first grade they got and the second grade, or yeah? How's that going to be done?
No, based on whatever your grade was, I'm going to look at that grade versus that grade from 100. And that's what I'm going to mark it out of.
If I need an enhancement, Miss Archer,
And
and
hold
I'm not in Nassau. How do I get that?
Mr. Pratt love to arrange it.
Okay, so message Mr. Pratt.
Yep, he already
Okay.
here.
Just next week, Wednesday.
No, it's this one.
Oh, okay.
This is not difficult.
You said it's not case law. So if it's not case law, is it more like the course material subject matter?
Yes.
Okay. Again, asking for a friend.
Okay, keep asking for a friend. Very simple. This is very, very simple. Not hard. Like one simple question. There's only one I'm giving you all.
It's one question?
That's one question I'll give you so you can see how simple it is. Explain the mortgagee's power of sale. See how simple it is?
Yes.
Okay,
Okay,
it's not difficult. It's not difficult at all. So I will remind Mr. Pratt.
so I have to reach out to Mr. Pratt, Miss Archer.
Yeah, you can reach out to him. Okay. And I'll also ask him to send the precedents.
All right, thank you.
Okay. So those who need to study, please go and study.
Miss Archer, the case that I had to present tonight when my internet keep dropping.
Next
we'll
week.
do next week?
Yeah,
Okay,
yeah. Next week. And I'll try find some other ones. But we'll do that next week. So I'll look for some stuff to see what I can do. To bring it home so you can understand better. All right, so I'm sorry it's dark.
No worries.
6 p.m. Wednesday.
6:30. 6 o'clock. 6 o'clock. Yeah, 6 o'clock. Good time. All right. No
Yes,
need to
ma'am.
be afraid. No need to be afraid. It's not that difficult. This is just the basic. So what I did was look at the multiple choice questions and then I just formulated my very simple questions. So no one should be pulling out their hairs. All right.
okay.
Okay. So I will see you all next week.
All right, good night.
Good
Good
night.
night, everyone. Have a good one.
Yes.
And everyone.
Miss
Good
Miss
night.
Archer,
All.
you want me to press stop recording? They made me the host.
I see that. Yeah.
Good
Press
night.
stop.
Good night.
Good night.